You own rental properties in California, maybe a few rentals, maybe a portfolio you've been building for 10 years or 15 years. And at some point, someone told you to set up an LLC, so you did. Maybe you have a trust too. You've checked the boxes. You feel like you've done your homework. Here's the problem nobody tells you, especially if you have not done the planning the right way. A plaintiff's attorney can open up a laptop, run a public record search on your name, and have a complete picture of your assets in about 20 minutes. Your LLC, your properties, the equity sitting inside of them, all of that. And if the picture looks like a payday, unfortunately, they're going to file the lawsuit. By the end of this video, you're going to understand how that arch actually works, what makes someone look like an easy target versus a headache not worth pursuing, and the 3 questions you should be asking about your current setup right now, because the gap in most California plans isn't obvious until someone tests it. Here's what I mean. A creditor's attorney isn't deciding whether you're guilty of something. They're making a business decision. What does this person own? How is it held? What does recovery actually look like after litigation costs and years of fighting? That math has to make sense before they file. A person with no real planning answers that question immediately. Real estate in their personal name, bank accounts exposed, equity sitting in plain sight. The attorney has the number in 20 minutes. They're going to file and they're probably going to win. A person with a real plan makes that same attorney put their pencil down. Ownership structure under multiple entities, membership interest held inside trust with protective provisions, equity not visible on a surface level search. Suddenly, the attorney is looking at charging orders, trust spendthrift clause, holding company structures, and the question of whether a California court even has jurisdiction over all of it. The cost of pursuit goes up, the certainty of recovery goes down, and the rationale moves from full litigation to easy settlement or walking away. After structuring these plans for hundreds of California investors and business owners, the thing I tell every client is the same. Your first goal isn't winning in court. Your first goal is not being the most attractive target in the room. Now, most people who think they have already handled this are actually sitting on a plan with at least one of the 3 problems, and I want to walk through all 3 because any of them can unwind everything else you've done. The first problem is the single member LLC. In California, under Corporation Code Section 17705.03, a court can go beyond a standard charging order when you have a single member LLC. They can foreclose the membership interest, appoint a receiver, and pursue remedies well beyond what a standard charging order allows. A single member California LLC is not a wall. It is more like a speed bump. The multi-member structure with a Wyoming holding company above it is how you solve this, and we will go deep on that structure in the next video. The second problem is the revocable trust as the LLC beneficiary. A revocable trust is an estate planning tool. It avoids probate and all those sort of planning. It does not protect assets from your creditors. If your membership interest in the LLC is held by your revocable trust, a creditor with a judgment against you personally can reach that membership interest as if it were owned under your name. They're not reaching the LLC's underlying assets directly. The LLC still provides that separation, but they can obtain a charging order against your interest. And in some cases, particularly with single-member LLC, they can pursue stronger remedies. The word trust does not mean protected when the trust is revocable. People misunderstand that constantly. The third problem is the irrevocable trust, where the grantor, that's the person who creates the trust, is also named as the beneficiary in the trust. Here in California, under Probate Code Section 15304, if you create an irrevocable trust and name yourself as the beneficiary, creditors can reach the trust assets. California has no domestic asset protection trust statutes. States like Nevada, South Dakota allow self-settled trusts with creditor protection after a waiting period. However, California does not have anything like that. If you want genuine irrevocable trust protection here in California, the grantor, you cannot be the beneficiary of the trust that you've created and put your own assets in there. In a later video, I'll walk through exactly how the trust is designed so that you still retain meaningful indirect influence over how those assets are managed without being named as a beneficiary. So you can lean on a single member LLC, you cannot rely on your revocable trust, and you cannot be the beneficiary of your own irrevocable trust. Which raises the obvious question, what does a plan that actually works in California looks like? It's a layered system. Each layer adds friction. No single layer is enough on its own, but together they make the economics of pursuing you look very different to the attorney running that 20-minute asset search. Insurance is layer one. You got to have the right landlord policy, commercial coverage, umbrella policy. This insurance realistically absorbs the initial hit and funds your defense. Entity structure is layer two, a land trust at the property level, so your name doesn't show up in the county recorder's office if it's structured correctly, and you're not named as the trustee of the land trust, a California operating LLC to isolate liability, and a Wyoming holding company above it because Wyoming's charging order protections are stronger and they apply even when the underlying assets are in California. Trust structure is layer number three, and this is where you take a solid plan and make it genuinely difficult to attack. The base structure, the land trust, California LLC, Wyoming holding LLC, revocable trust already creates meaningful friction, obstacle. The goal is to make it a lot more difficult for a creditor to attach or get to our assets. The entity layers separate the property assets from the judgment debtor, and the Wyoming charging order protection applies. In most cases, even with California-based real estate portfolio, a creditor who gets a judgment against you personally is not walking into the LLC and taking the property. That is not happening. They're getting a charging order against the membership interest you have in the Wyoming holding company. And then they'll have to wait around in most cases until the actual LLC makes a distribution, and that may not happen for a while. But if you have this structure and you have the Wyoming LLC's interest held by your revocable trust, there is a gap. The membership interest itself is reachable because the revocable trust provides, as I mentioned, no creditor protection. That is where the irrevocable trust comes in, not as a replacement for the base structure, but as an additional layer on top of it. Here's how it works in practice. You do not transfer the entire Wyoming interest into the irrevocable trust. Usually, you transfer a fraction of it. You split the membership interest into voting and non-voting interest. This is very similar when you set up a limited partnership. You have a limited partner and a general partner. This is the same thing if you have a voting and non-voting. The voting interest, let's say 50%, will go into the California third-party irrevocable trust where the grantor is not named as a beneficiary, which could give you an immediate creditor protection. The non-voting interest will stay in your revocable trust where you retain direct access to the income that flows through that 50%. If we do split the Wyoming holding company into two separate members, that split also matters because it will make our LLC a two-member LLC. The irrevocable trust is one of the members and the revocable trust is the other member. That strengthens the charging order exclusivity significantly compared to a single member structure. And we cap, in most cases, the allocation to the irrevocable trust at 50% because in most cases, if you do transfer more than 50% of a LLC membership interest to an irrevocable trust where you or your spouse are not the beneficiary, the present beneficiary, that could cause reassessment of the entire assets that are inside of the irrevocable trust, particularly real estate is what I'm trying to say actually, that those assets will be reassessed. And we don't want that to happen. So this structure, the land trust, the layered LLCs, the bifurcated membership interest, the California third-party irrevocable trust, is the domestic asset protection ceiling. It works well. It works well for a lot of investors. However, it is still sitting entirely in California's court system. A California judge can interpret your trust, order discovery into your entities, and issue remedies under California law. There is no jurisdictional barrier. For investors with serious exposure, significant equity, an active business, or a history of litigation, the domestic ceiling isn't high enough. That is where offshore planning starts, and that's where this series is heading. For now, here are the 3 questions to run your current plan. Is any of your real estate held directly in a single member California LLC? If yes, that charging order protection is weaker than you think. Are your LLC interests held by a revocable trust? If yes, a creditor may be able to reach them. Do you have an irrevocable trust that names you personally as the beneficiary of that trust? If so, under Probate Code Section 15304, that asset protection trust may not provide you any protection. If any of these answers is yes, the next video is where we fix it. I'm going to walk you through the full California domestic playbook, the land trust, the LLC layering, the voting and non-voting membership interest, and why the 50% cap is one of the most important details most attorneys never really mention. If the domestic foundation isn't solid, nothing you build on top of it is going to hold. Go watch that next video, and I look forward to seeing you over there.